Hello friends and welcome back to the first edition of the revision series of the JIGL subject for the upcoming December 2025 examinations. Now in this video we're going to be starting out with chapter number 6, that is your Code of Civil Procedure. For those of you who are new to my channel, my name is Anuja and I have curated this revision series keeping two main objectives in mind. One is that the series is going to be entirely in English and it's going to be a coverage of the entire ICSI module. So in these series, I'm going to be referring to notes that I have created and curated for the purpose of easy understanding and revision. Not only the notes, I have also curated a case law sheet individually for each and every chapter. So in these case law sheets, you can access the topic, the name of the case law, that is the case law which comes under that topic, and what was the decision. So this relates to all the important case laws in the JIGL subject. So if you want access to these notes and the case law sheets, then I've given detailed inscriptions in the link in the description below. Then you go ahead, access these notes, access the case law sheets, and then let's start our revision. So we're starting out with chapter number 6, that is our Code of Civil Procedure. Now, to understand the Code of Civil Procedure, we need to basically curate one simple flowchart in our mind. Because once we understand this flowchart, then the entire chapter becomes very, very simple and very, very easy. So this entire flowchart starts with an understanding, first of all, of our codes of law. So as we know, the codes of law in our country are largely divided into civil and criminal codes. But here, for the purpose of this chapter, we're referring entirely to civil codes. Okay, so when we look at the civil codes, the loose or the large classification of civil codes is that at the highest level, we have the Supreme Court. Beneath the Supreme Court, we have the High Court, and below the High Court, we have the lower courts. Now, these lower courts are what we call as our civil courts. Please understand, again, this is a very loose explanation of our court system. And every time you wish to start a suit or any kind of suit needs to be instituted under the CPC, you first have to approach the lower courts and then move upward in appeal. This is the principle of how our courts work. So you always approach the lowest court first, and then you go on appeal to the High Court, and then you go on appeal to the Supreme Court or the higher court, basically, depending on the law that you are referring to. So, keeping this thing in mind, let's now try to understand what is the process that happens in a court of law. So friends, for the purpose of understanding the CPC, we are going to keep one example in place, and this example is what we're going to be following or building upon through the entire course of this CPC chapter. So let's try to understand this example. Let's say that there is a person named Arun, and Arun owns a property which amounts to 5 acres of land. 5 acres of land is owned by Arun. Okay, great. Now, since Arun owns this property, let's try to describe this property a little bit in detail. So, the property itself looks something like this. Let's build a square property amounting to 5 acres of land. Now, Arun has a house which is situated over here. So the house is situated in one corner of the property for Arun. And in this property, what Arun has done is there is a pathway which leads into this property that goes in like this. And then the road eventually steps out like this and goes into the house itself. So the purple line is the road and the green is the house. Okay, so this is exactly how the property is situated. Now, since Arun is, for whatever reason, Arun wishes to sell a portion of this property, and what Arun does is he subdivides this property into two parts. Now, when he subdivides the property, he divides it into a portion which then becomes 3 acres, and this becomes 2 acres of land. Okay, and this 2 acres of land, 2 acres is sold to a basker. So I hope you're understanding the simplest part of this example. One, Arun holds property, and out of that property, he is selling a portion of that property to Bhaskar. So, what happens when there is a sale? There will be a sale deed and subsequent documents attached to that sale deed. Okay, great. Now, one thing that Bhaskar realizes as a problem is that when he buys this property, there is one small problem. There is only one way to enter into this property, and that is the road marked by the pink line. Okay, so then Bhaskar then tells Arun this, and Arun states, "Okay, no worries. Let's do one thing. I will provide a way into your property. I will provide a pathway for you to enter into your property that is separate from this path." So, how exactly does Bhaskar intend to do that? How does Arun intend to do that? He intends to give a pathway directly into this land. Okay, but maybe this is not possible, and so what we can end up seeing is that the pathway has to enter from here and then go in like this. For whatever reason, the pathway has to go like this. And the cost of building this pathway is 2 lakh rupees. Okay. For an assumption's sake, the cost of building this path is 2 lakh rupees. So what Arun states is that, see, anyways, you're in the process of building a house on your own property. Since you're already having construction, you do one thing, you also build the pathway into your own house, but I will reimburse the 2 lakh rupees to you. I will reimburse the entire cost of your transaction to you. So let's come back to the elements of the sale deed. In this sale deed, 2 acres is sold, but also Arun has to reimburse the cost of building the path. All right. And what actually ends up happening is that instead of 2 lakh rupees, the cost ends up becoming 4 lakh rupees. Now, ultimately, Arun was supposed to reimburse the cost of building the path. So we're assuming that it was 2 lakhs, but it actually cost him 4 lakh rupees. And Arun was not entirely clear about how the path was going to enter into Bhaskar's land, but Bhaskar went ahead and built the land. You see, while building this pathway, Bhaskar ended up taking quite a bit of the land to the 2 acres, such that the actual property that was now being taken up by Bhaskar became 2 acres. Instead of just 2 acres, it ended up becoming 2.30 acres. Now, this matters in terms of property. Okay, and there is a reason why I'm coming to this point over here. Instead of the original 2 acres that's being sold to Bhaskar, an additional 30 cents was being given to Bhaskar for the pathway. And the problem is, Arun was not entirely aware of how much of this property would end up going. And so, when the construction starts and this pathway is being built, Arun comes to find out that a major 30 cents of his land is being dug out and being built for the pathway into Bhaskar's property. And so he goes and he tells Bhaskar, put a stop to this construction. Bhaskar says no, it was all in accordance with this sale deed. This was in agreement with between the both of us, and I will not stop. I will continue building. And more importantly, you have to reimburse me 4 lakh rupees because that is the cost of building this pathway. Now can you see where a dispute is arising? A dispute between two individuals, that is an Arun and a Bhaskar. Now, in a very simple transaction such as a sale of property, simply because the elements were not properly defined, there is now a dispute which is arising. Now, let's take the assumption that in this case, the parties have tried talking to each other and no reconciliation is possible. So then what we can see is Arun will have to end up going before a court of law. Okay, great. So now, if Arun is to go before a court of law, then can he do so? The answer is yes. Arun can approach a court. This is the first element that we're going to start seeing with respect to how your CPC starts. So, what can we understand from here? That Arun is an individual and Arun has some kind of a right which is violated. What is the right? The right arising out of a sale deed. The terms of the sale deed were not clearly defined, and Arun believes that some right is being violated. And even though Arun has gone and asked Bhaskar to put a stop to the construction, Bhaskar is not stopping. Okay, so now Arun decides, okay, I have no choice but to the court of law. But now the question is, which court of law should he go to? Which court should he go to? Because there are so many courts around here. Okay, and that is why, for the purpose of determining which court a person should go to, we talk about the concept of jurisdiction. Okay, friends, so jurisdiction is going to be one of the major topics that comes up in the concept of civil law, because only based on the jurisdiction we can decide which court to go to. And therefore, what is jurisdiction? Jurisdiction is nothing other than the power of the court to hear a matter. So, the power of a court to hear a particular matter is what we call as the jurisdiction. And that is the first thing that we have to look at before Arun decides which court of law he should go to. Now, for the purpose of building on this example, let's assume that Arun owns the property that is located in Coimbatore. Okay, so this Coimbatore is in the state of Tamil Nadu. So, therefore, we have to now find a court that is within the jurisdiction of the Tamil Nadu courts, because that is where the property is located. Great. This transaction, this sale deed took place in the year 2021. Today, let's say today, the year is 2025, nearing the end of the year 2025. Now, the question is, when all these issues happened, is it right for Arun to come before the court of law after 10 years, or after 20 years, or even after 30 years, or after 50 years? No. Arun should try to come before the court of law within a specified amount of time. And this has its own reasons, and that reason is what we call as the limitation. Now, the concept of jurisdiction is something that we will be seeing in our civil procedure code itself. But limitation is a concept which we will be discussing in the Limitation Act. So, if you want to do a revision of the Limitation Act, then I will be putting up a video very soon with regards to Limitation Act. Go ahead and watch the revision video for that chapter 2. Okay, great. So now Arun decides to go to the court of law. He has to choose the court of law based on the jurisdiction, and he will be tied up by the concept of limitation too. Great. Now, after deciding both the jurisdiction and the limitation, when he approaches the court of law, what is Arun required to do? Does he just go and stand in the court premises and wave at the judge and say, Your Honor, please listen to my matter? No, there has to be some kind of a formal proceedings that have to take place. There should be some way of him conveying what is the issue to the judge. And so that is done through an essential document which we will call as the plaint. So friends, the first topic that we talk about is jurisdiction. The second topic that we'll be talking about is limitation. The third topic that we will be seeing is known as a plaint. So now we need to understand what are the contents of this plaint. So let's try to understand the contents of the plaint from here. What is a plaint? First of all, a plaint is nothing other than a document which has to ascertain a few elements within the plaint. The first one is that the facts leading up to the problem have to be identified and mentioned. And the facts eventually will give rise to something known as the cause of action. Great. So what is this cause of action? I will be referring to this cause of action as COA from now on. Anytime I'm referring to cause of action, I will be referring to as COA. Okay, great. So what is this cause of action? A cause of action is nothing other than the set of facts facts, the facts which identify when the plaintiff's rights were violated. Okay, I hope this is clear. Facts which identify when the plaintiff's rights were violated. Because only when a right is violated can a person even go before the court of law. Great, who is the plaintiff over here? The person who's submitting the plaint is known as the plaintiff. And that brings us back to Arun over here. And Arun is who we call as the plaintiff. So, in short, I will call him as P. In short, plaintiff. So now we're still talking about the plaint itself. A plaint is a document which determines the facts and ultimately the cause of action leading to when the cause of action is nothing other than when the rights were violated. Now, apart from the facts, the Arun has to give the necessary evidence to support his claim. Okay, because he has to determine, see, the sale deed said this, or this transaction happened, or some kind of document to support his arguments should be provided. So the second thing is evidence needs to be given, and evidence is a topic that we discuss under the chapter BSA or evidence law. Then the third thing is which law is he approaching under. Under which law is he approaching? Which right is being violated over here? That needs to be mentioned. And then one of the most important things that have to be claimed is something that we call as a prayer. That means a prayer is like a prayer, like how you pray to God, you're praying to the judge to give some form of a remedy. To give some form of a remedy over here. So, what could be the remedy that Arun needs over here? First and foremost, Arun needs Bhaskar to stop doing the construction over there. Second, Arun needs Bhaskar to stop the construction so that his right to his own property is not being violated. Now, since Bhaskar has already dug up all of the land and there is already damage being done to the land, Arun might require that even money be paid to him in the form of compensation. So the example of some remedies that we can say here is one, put a stop to the construction. Put a stop to the construction. And the second remedy that he can ask for is money in the form of compensation. So can you see now how the first document that is known as the plaint has to be submitted by the plaintiff before the court of law? Okay, great. Now that we've understood what and all has to be there in the plaint, let's come back to our flowchart over here and try to understand what is the next step in process to the court of law. You see, the court cannot hear only one person's arguments. The court will also have to call the other person before it and hear the other party. So therefore, what the court will do is the court will issue something known as a summons. And so the fourth thing that we will see is the concept of summons. Okay, so what is the summons? Summons is a document calling the defendant to the court of law. Within how many days should the court send the summons? Within a period of 30 days. Okay, so now let's try to understand a little bit about summons after the plaint is given. So once the plaint is given, the summons is issued. The summons is issued to whom? To the defendant or the person named in the plaint as the defendant. Okay, great. So the question is, who should send the summons? The answer to this is that the court of law will usually send the summons. All right, but it's not only the court of law that needs to send the summons. Even the plaintiff can send it to the defendant. But if the plaintiff is sending the summons, then they should show proof of sending. The proof of sending the summons has to be given has to be shown to the court of law that the defendant really got the notice of summons. And this is usually done through a method that we call as a registered post acknowledgement due, or through some form of a courier service that the courts recognize. Great. So within what is the time period to send the summons? The answer is within 30 days. So within 30 days, the summons should be sent out. And who should it be sent it to? It should be sent to the defendant. Great. Now that we've understood that the summons has been sent to whom? To a person known as the defendant. In this case, the defendant is no one other than Bhaskar. So in short, I'm going to call him as DEF, DEF. Okay. And the defendant is no one other than the person who violated the plaintiff's right. Correct? And in this matter, he has to defend himself before the court of law. Now, the defendant, he's being called through the summons to submit a particular document, which we will refer to as the written statement. So can you see a plaint is being summoned to, it has been issued to the court. The court is issuing a summons within a period of 30 days, and the defendant is now asked to come before the court of law and submit a written statement. So now let's look at the concepts of how a written statement works. So the fifth element is being a written statement. What is a written statement? A written statement is also a document submitted by the defendant. Please keep note of all of the short forms that I'm using over here. And great. Now, if this is a document submitted by the defendant, what should it consist of? First and foremost, it is purely a reply to the plaint. It is only a reply to the plaint. So if the plaint has 10 paragraphs, then the written statement should be a reply to first para 1, a reply to paragraph 2, a reply to paragraph 3, reply to paragraph 4. Either it is accepting something or it is denying a statement. So if, for example, in the plaint it is written that the sale deed was executed on this date. It's given in paragraph number 1. For that, the reply in the defense statement will say that yes, there was a sale deed that was executed in on so and so date. Then paragraph number 2 will say that the Bhaskar has gone beyond the scope of the sale deed. And in this case, Bhaskar will say, no, I have not gone beyond the scope of the sale deed. So look how the plaint is a complaint and the written statement is a reply to that complaint. Either it is accepting or it is denying. It's saying, yes, this is the case, or no, this is not the case. Ultimately, it is a reply to the plaint. Now, obviously, there's a reply to the plaint if the defendant is relying on some additional claims that he's making, then he should also provide certain evidence to support his arguments. Okay, and in addition to the written statement, some additional things can be claimed by our defendant, and that is nothing other than a set of or a counterclaim. What is a set off or a counterclaim? We'll be looking at it in detail later. Set off is mostly related only to money or in the form of a debt, whereas counterclaim is anything else. Anything that does not relate to money, but it can be something related to other rights is known as a counterclaim. So in a written statement, it first and foremost has to be only a reply to the plaint. The evidence to support your argument should be given, and a set off and a counterclaim can also be claimed. So this is optional. If there is a set off, it can be claimed. If there is a counterclaim, it can be claimed. Great. Now that this document, I mean, there's a written statement like this. What is the time period within which this has to be submitted? So the time period that it needs to be submitted is actually 30 days. But for whatever reasons, if the defendant needs to go find a lawyer, prepare his case, present his case, etc., it can extend even up to 90 days. And this is in normal court proceedings. But then, with respect to the Commercial Courts Act, this is a special law. They're saying that it can even be the Commercial Courts Act, it can be 30 days and may sometimes even go on till 120 days. Okay, so this is the time period that we can see with respect to submitting of this written statement before the court of law. Okay, great. Now that we've got the written statement submitted, what is happening over here? You see, the plaint was a complaint. The written statement was a reply to that complaint. So, in a way, if para number one could have been accepted, para number two could have been denied, para number three could have been denied. Okay, so ultimately the court, the judge is going to have to read through the full plaint, he's going to read through the full written statement, and then finally, on the basis of what is being, choose a different color for this, what is asserted, that is what is being complained by the plaintiff and denied by the defendant, will form something known as issues. So the issues becomes the sixth thing that we are looking at. Let's read it again. What is asserted by the plaintiff or what is complained of by the plaintiff and denied by the defendant forms something known as the issues. Who forms these issues? The court forms these issues. Okay, so what are issues? Issues are nothing other than questions. Whether it's question of fact or whether it's question of law, ultimately it is a set of questions that the court is determining. You see, because one party is coming with certain information, the other party is coming with certain information, how to bring it down into one collated information such that the rest of the trial can proceed on the basis of those issues. We can only look at that by looking at what is complained of by the plaintiff and what is denied by the defendant. But why is it only that whatever is complained of and what is denied? What if Arun complained of something and Bhaskar said, yes, that is correct? See, if I am complaining against you and you say, yes, it's my bad, I'm really sorry, then is there really a dispute over here? The answer is no. So, only when I am complaining something against you and you are denying it, only then I can say that there's a dispute. So the same thing applies before the court of law, and that is why these issues are created. And at the time that these issues are created, we can essentially say one essential element of this proceeding start, and that proceedings is what we call as the trial. Now, what is the trial? We will be looking at it later with respect to some concepts known as res judicata and sub judice, but keep this in mind. Okay, now that all these documents are provided, one small issue is over here with respect to the evidence. You see, with respect to the evidence, sometimes the parties may rely on some evidence, but they may not have it physically in their hands. Then what to do? The answer is they can mention it in their documents. They can mention it in the plaint or in the written statement, and they can submit it at a later point in time. So, what is that later point in time? It is usually after the trial starts. So, what happens in the proceedings of a trial? In a proceedings of a trial, basically, after all the documents are submitted, essentially the arguments take place. The arguments first by the plaintiff and then subsequently by the defendant. And then, alongside the arguments, you may also have something known as cross examinations and counter arguments. Okay, so this is a form of an argument stage. And then remember, I told you that the evidence that was relied on earlier will have to be submitted. Well, you see, just because evidence is submitted, the court is not going to take it as completely true. Evidence can also be rebutted. That means it can be denied. The other party can come and say that this evidence cannot be accepted in a court of law. How will these arguments be made? Well, for that we have to refer entirely to the evidence law. But for this purpose, we'll just assume that this stage of submitting of evidence, rebutting of evidence, and acceptance or admission of evidence is happening at this stage. And then, on the basis of all the arguments, the evidence, etc., ultimately, the court will hear this entire matter. So, this is how the hearings take place. The hearings will be given, chances will be given to both the parties to bring their witnesses, submit documents, give arguments, etc. After all of this is done, ultimately the court will come out with the judgment. Okay. Now, it is very common for all of us to simply say, yes, courts give judgment. But the legal term of the judgment is nothing other than a statement. Okay. And so the judgment is the next thing that we're going to be looking at. So if issues are point number 6, then the judgment is point number 7. So what exactly is a judgment? A judgment is nothing other than a statement declared in a court of law. And what does the statement do? This statement basically determines the rights and liabilities of the parties. What does this mean? For this, we'll go back to our own example. Okay. So over here, in our example, when we come back to the example itself, what can we understand over here? That there is an Arun and then there's a Bhaskar. What can we understand from Arun's point of view? That he sold property to the defendant, but then instead of taking just 2 acres, they went ahead and took a lot more land. And that essentially over here, his right is being violated. What is his right? Encroachment into his property. Okay. Now let's try to understand what will be the rights and liabilities of Arun and Bhaskar over here. Now for this, we can look at it from two ways that this judgment can go. So the first way is when if the court says Arun is the true owner of 3 acres of land. So let's write that down. Arun is the true owner of 3 acres of land, and that Bhaskar has encroached upon the land. Okay, with the tuning to the amount of 30 cents of land. See guys, immovable property is very valuable. So whether it is 1 cent of land or whether it's 2 cents of land, ultimately at the end of the day, there has been an encroachment. And so therefore what the court has said over here is that the court is saying that Bhaskar has to pay a compensation amount to Arun to the tune of 10 lakh rupees. Maybe a little more than 10 lakh rupees, but let's just assume for example's sake that to the tune of 10 lakh rupees, Bhaskar has to give Arun. Now, what about all the costs that Bhaskar incurred? Bhaskar would have incurred some cost for the purpose of digging up the way. The court will simply say that, no, sorry, Bhaskar, you're not getting any money. Bhaskar has to pay a certain amount of money to Arun. This is one way in which the judgment can be given. But is it enough to do all of these things? No. The court will go ahead and say, okay, stop all construction. Stop all the construction on his land and give him the entire enjoyment of the land to Arun. So this is one way in which the decision can go. Now again, we're going to build up on this example a little bit over here, and we're going to go back to certain topics that we have seen before. You remember how we said that when we're talking about the plaint, that there are some prayers that Arun asked. He can ask them to stop the construction, or he can ask for some form of compensation in money. Now, don't you think that the defendant should also ask for some form of a prayer? Correct? A prayer should be asked even by the defendant. It's not just the reply to the plaint and evidence or set off or counterclaim, which is optional. No, even a prayer should be asked for. Now let's try to understand this in a little bit of detail. Okay, let's look at it from the point of view of Bhaskar's point of view. Now, what Bhaskar thinks is that, see, yes, I've got the 2 acres of land in this sale deed, but I have no way of entering my land. And that is why Bhaskar went to Arun and said, see, only if you give me a pathway, I can enter my property. And so there was an oral agreement between Bhaskar and Arun stating that, okay, you go ahead and build the pathway, that Arun will reimburse the land to you, reimburse the money to Bhaskar. So don't you think that at the end of the day, that Bhaskar will also have certain rights which are being violated? that he can ask for some kind of a money claim. So in his prayer, Bhaskar will say, listen, I incurred 4 lakh rupees for the purpose of building this pathway. I want a reimbursement of that 4 lakh rupees. And in addition to that, that the 30 cents of land should be registered in Bhaskar's name. Please understand that this is the prayer, correct? Can you all now understand how this is happening? We are seeing that we are seeing this from Bhaskar's point of view, that the 4 lakhs that he incurred has to be given back to him, and the additional 30 cents of land that was required to build the pathway into his property should now be registered in Bhaskar's name. Because Bhaskar is claiming that yes, the sale deed did say a sale of 2 acres of land, but the oral agreement contained a 30 cents additionally. So now let's come down to my bad. Let's come down to an alternative judgment that can be given by the court. See, in judgment number 1, the court is favoring Arun entirely. But don't you think there's a probability that even Bhaskar could have been correct? So there's a probability that now they'll say Bhaskar is the owner of 2 acres plus 30 cents of land. Okay, the 2 acres was given through a sale deed, whereas the remaining 30 cents was additionally got through this judgment of the court. And in addition to that, Bhaskar is also entitled to, Arun should pay Bhaskar a tune of 4 lakh rupees. Because Arun did claim that he has to pay, he will reimburse Bhaskar for the cost of the road, no matter what the cost was. So this is also an additional way in which the judgment can go. So what is happening in both these situations? Don't you think rights and liabilities are being determined over here? In the first situation, Arun is now having a right being, he is now declared as the true owner of the 3 acres of land. But then in the second situation, Bhaskar is being declared as the true owner of 2.3 acres of land. In the first situation, the court is saying that Bhaskar has encroached and that Bhaskar should pay 10 lakh rupees over here. Don't you think we call this as a liability? This is a liability, correct? And the same way, even with respect to in the second situation where Arun has to pay 4 lakh rupees to Bhaskar, that is also a liability. So this is how a judgment determines the rights and liabilities of parties. Okay, now the judgment is not the final activity of the court of law. You see, with respect, after the judgment is made, an other thing takes place. What is that other thing? We can say that the other thing that takes place is that a decree should finally be given. What is a judgment and what is a decree? See, judgment is the statement, but the decree is the final action of the court. It is the final document to be given by the court of law that states that this proceedings has come to an end. Okay, and that is the decree. Now, usually the decree will consist of both the judgment and the decree together will be given on the same day. But sometimes the judgment is given first, followed by the decree. And the time period within which this has to take place can be anywhere between 14 days to even 30 days. Okay, and it is only when the decree is given can we say that the proceedings of the court have finally come to an end. So I can actually break it down in a way and say that when a plaint is filed, so just consider this as notes, okay? When a plaint is filed, you will get a decree. When a plaint is filed, you will get a decree. This is how suits work across the entire CPC. Okay, now there is some additional factors that we have to consider over here. You see, the problem was when we come back to our example, Bhaskar in this 2 acres of land has already started construction. Now, should Arun wait for him to finish construction, lay out the full road, finish everything, enjoy it for 2 years, and then go and complain in a court of law? No, he has to put a stop to it the minute the problem arises. So, actually, if the construction of this pathway is still ongoing, then and there, Arun is going to the court of law and he's filing a plaint. But you see, look at the time period. Let's just try to ascertain a time period that it takes for a plaint to be instituted and then a decree to be given. Okay, the time taken to prepare a plaint, appoint a lawyer, sign a wakalat, and then actually get it submitted before the court of law may take a little bit time. Then the court will send the summons up to a limit of 30 days. So there itself another 1 month has gone by. Then the defendant has to respond anywhere between 30 to 90 days. So that's another that's either 1 month or even 3 months which has gone by. And by the time the court raises issues and then there are hearings, the evidence is given, and all of this, anywhere between a minimum of 6 months goes by. Don't you think it would 6 months is more than enough time for Bhaskar to finish constructing this entire road, constructing his starting construction of his house also, and everything will get done? So there's a problem of a time period over here. And now if Arun has to go to the court of law, but he has to wait more than 6 to 8 months to get any form of a remedy, then that's going to be a problem. So what the CPC actually understands from this is that, okay, if a person requires some immediate remedy, please understand, if the people require some form of an immediate remedy, and I'll write this down for you. Then what the parties, and please understand, this can either be the plaintiff or the defendant. The plaintiff or the defendant can file an interim application. I will refer to this as IA. So, an interim application can be referred to can be filed to the court of law by the plaintiff or the defendant. And what is this interim application? This interim application will give rise to an interim order. An interim order. So, if you file an interim application, you'll get an interim order. What is this interim order? What are some examples of this interim order? The first main example that we see is known as an injunction. What is an injunction? An injunction is nothing other than a stay order. Stay, put a stop to it. Put a stop to the construction right now. Let the court first determine who is doing the problem, or whose rights and liabilities are being violated. Until we decide that, put a stop to it. Bhaskar has to stop construction. Arun should also not go and do anything to Bhaskar. Stay order. Okay, this is only one type of an example of interim order. There's a second type of interim order that we do see in a little bit later on, maybe. We also call this as an interim sale. There are multiple types of interim orders. One such type is what we call as an injunction. Okay, so you can in this current matter, let's say that Arun is going and filing for an injunction immediately. He wishes to get a stay order. He wants to prevent Bhaskar from continuing with the construction any longer, right? So what will Arun do? He will file an interim application before court of law, and the court will give an interim order. So when we're writing our notes, I'd like you to note another one also. If a plaint is being submitted, then a decree will be given. If an interim application is made, then an order will be given. Okay, so let's try to understand exactly what is this interim order. An interim order is a temporary measure. Okay, temporary means, what does it mean? Basically, until the judgment or the decree is given. Are you clear on this? So if there is some kind of an interim order, that means it's already of a temporary nature. For the time being, it is applicable. And this will usually apply until the judgment is given. Now, can it apply even after the judgment? That will be determined at the judgment stage or at the decree stage. Okay, great. Now that we've understood what all happens till the actual passing of a decree, what can we understand from this concept? One, there should be a plaintiff and a defendant. Okay, so as we can see over here, there should be a plaintiff, there should be a defendant. The plaintiff should submit a plaint and the defendant will submit a written statement. But the plaint, while it is being submitted to the court of law, a summons has to be sent to the defendant. And where should the plaintiff go? He should go to the court having the correct jurisdiction and the correct limitation. Now, once both the plaintiff and the defendant are brought to the court of law, and both of them have submitted the plaint and the written statements, then an issues will be formed. Either like one or two questions or a series of questions. These questions are determined based on what is complained of or what is asserted by the plaintiff and what is denied by the defendant. On the basis of this, once the issues are formed, we say that the trial starts. Now, when the trial starts, this is where you have the arguments, the cross examinations, the evidence, the rebutting of evidence, etc., and the hearings take place at this stage. And then finally, the judgment is given by the court of law. A judgment merely determines the rights and liabilities of parties, and on the basis of a judgment only, a decree will be given. Now, since a judgment is merely a statement, it can be declared even in open court of all. Whereas a decree has to be in the form of a document which has to be given as a copy to both the parties. Now you see, when a decree is issued, a decree does a set of things. But first and foremost, we have to understand that there are two types of decrees. There is a preliminary decree and there is a final decree. Okay, there are two stages to a decree. It doesn't apply to every single one, but in some cases it is there. Now you see, as a result of the decree, two types of people are being created. What are those types of people is nothing other than one, the decree holder. Who's the decree holder? Basically, in favor of whom the decree was passed. So in this situation, it can either be Arun or it can be Bhaskar. And automatically, the other person ends up becoming a judgment debtor. Decree holder and a judgment debtor. Why do we call them as the judgment debtor? Because as a result of this judgment, that person is becoming the debtor. Do not confuse this with thinking that every decree holder, every plaintiff is the decree holder. No, even the plaintiff can become the judgment debtor. Even the defendant can become the decree holder. Ultimately, the decree holder is the person in whose favor the decree is given. And the opposite becomes a judgment debtor because many times a person becomes a debtor because of a judgment, in the sense that he is asked to pay up compensation of money to the other person. Okay, and this is the consequence of having a decree. Now, the thing is, with the decree, it doesn't just end with the decree itself. Okay, you don't see this happening only with the end of the decree. After the decree, some set of events can take place, and that event is only what we call as appeal. Now we already know what is appeal. Appeal is basically going on appeal to a higher court. So if the decree holder or even the judgment debtor are not satisfied with the decision, they can go on appeal to a higher court. Now, this appeal is not an inherent right, which means you do not have the automatic right to go on appeal. Every right of appeal is entirely dependent on the law which you are referring to. So, say for example, the law says no, you're not allowed to go on appeal, then you can't go on appeal. If the law says you can go on appeal, then you can definitely go on appeal. Okay, but appeal is not the only type of remedy that there is. Apart from an appeal, we also have concepts like review, revision, or even something known as a reference to High Court. Reference to High Court, appeal, review, revision. All of these are what I will call as additional remedies. Appeal is the one that we know of and which is probably well known amongst everybody. But apart from appeal, you even have certain other remedies which we will call as reference, review, and revision. So these are the next few topics that we will be looking at with respect to your CPC. So, with appeal, does it come to an end? No, there are some ancillary topics that we will also be discussing under CPC, such as we look at certain types of concepts. That is, we'll see topics like one, res judicata. We will be looking at res sub judice. Then we will be seeing what is summary judgments, summary judgments or summary suits. Then we will be looking at something known as inherent rights of the court, the inherent powers or the inherent, sorry, it's the inherent powers of the court. Okay. And then we will be studying a little bit about the Commercial Courts Act. Okay. These are some additional topics that we will be discussing in addition to everything that we have seen in this flowchart. So friends, we will be stopping with this revision over here, but I hope this flowchart was helpful for you in understanding what is the basis of your CPC chapter. Go ahead, go through this revision, go through these flowcharts, keep it in mind when you are referring to the revision video. And again, if you want access to these notes or if you want access to the case law sheets that I'm referring to, again, detailed descriptions have been given, detailed instructions have been given in the description below. Go ahead, refer to the notes and join me for the next revision video.